I'm Doug Lichtman, and in this video, I want to dig into the idea-expression dichotomy. I've told you in prior videos that there are two fundamental ideas of copyright law: independent creation and the idea-expression dichotomy. And so here, I want to look at a couple of the big cases to help us really think about the idea-expression division, this separation of, hey, we protect expression, but no, we don't protect ideas. And the cases I want to use are Baker versus Selden, Morrissey versus Procter & Gamble, and Feist. And at the very end, I'll do a really quick touch of a modern example just to show you where we are kind of now in our thinking. Let's start with the old case, Baker versus Selden. This is an old Supreme Court case, and it's a case about a book that taught a method of accounting. And let's just stipulate it that at the time, this was a pretty cool achievement. Businesses were keeping track of the economic information relevant to their business on, books with lots of pages. And our author realized that you could organize that information much more effectively. And you get a little taste of it on the screen now. He came up with a way of laying out the information in columns and organizing it with headings and horizontal lines that really helped you understand the flow of the economics of your business. And again, I'll ask you just to believe that this was a pretty big deal. He got a copyright in his book, and the case was about this question of what does that mean to get a copyright in the book? And we know what it didn't mean. We know it didn't mean that he controls the method of accounting. You and I could read the book, walk away, and do this method. We also know that it does mean that he owns a copyright in the book, in the sense that if I took the book and, to use modern technology, photocopied it cover to cover, no good. I'd be taking his word choice, his paragraphs, no good. The question was mainly about the middle. Like, all right, given those two extremes, what about the form? Can I copy the form? Not the whole book, not his paragraphs, the form. Because that's kind of the idea. It's a method of accounting where this is the method. Or if I can't copy the form, can I look at his form, get my own piece of paper, grab a ruler, and make one that looks almost the same? The case was struggling with these ideas. Famously, it's always cited just for the high-level point. The high-level point that you cannot get a copyright that covers the idea, in this case of the method. And the case kind of teaches us in those instances, if you want to control the idea, go to the patent system. The case then raises this little smaller question about the form. And I'll tell you, some courts today say, don't copy the form, get your own piece of paper. And the courts that do that, we say recognize a thin copyright. Thin, just pointing out we're stopping literal photocopying, but probably nothing more. Other cases come in and say, no, the form is so related to the idea. The form doesn't add much in comparison to the idea that they say, nah, we're not even protecting the form. Copy at will. But Baker versus Selden famously is just the traffic cop case. And it says, you want rights to the idea? Go to the patent system. And that just raises this smaller question of, well, what's that going to look like in practice? Can people copy the form itself? Later cases then got sharper, and that's why I put Morrissey in the list. Same issue, more modern case, I think a little bit of a cleaner answer. Morrissey is this case about contest rules, and I put the rule up on the screen. This is the expression at issue. Entrants should print name, address, and social security number on a box top and plate. Maybe you remember contests like this. You'd buy your mac and cheese, you'd rip off the top of the box, you'd write your name, address, and social security number, kind of weird, but yeah, we did back then, and send it in the competition. And again, the case was about not the idea of the contest. Copyright doesn't cover the idea, but the expression. Did the original party who wrote this have meaningful rights over these words? And there is some expression here. It's not precious, but there is some expression here. There is some word choice and so on. And the case struggled with, what do we do now? What do we do with this expression? And interestingly, the court said, even though there is expression, I am not protecting it. Here's the paragraph the court wrote. Let's read it, and then I want to parse it a little bit. When the uncopyrightable subject matter is very narrow, so that the topic necessarily requires, if not only one form of expression, at best only a limited number, To permit copywriting would mean a party or parties, by copywriting a mere handful of forms, could exhaust all possibilities of future use of the substance. In such circumstances, the subject matter would be appropriated by permitting the copywriting of its expression. Then they added this line, which I love: "We cannot recognize copyright as a game of chess in which the public can be checkmated." What's the court trying to say? Well, the court rightly says what's cool here is we have an idea that can only be expressed in a limited number of ways. Maybe one, maybe a couple, but a limited number of ways. And that's right. And between you and me, I think that tells me I'm not really excited about the expression. Right? The expression basically came from the idea. Once they tell you the idea, there are only a couple ways to express it. I think it's a flag for the expression isn't all that impressive. And in the court's mind, it's a problem, because the court seems to be thinking, wow, what's going to happen is someone will come up with the idea, they'll write it up 6 times, and then they'll own the idea. And the court says, I'm worried about that, so I'm not going to protect the expression. And to some degree, that's not crazy. If you think about this case, I think our copyright holder was trying to control the idea. That's really what was going on here. They didn't care so much about these words. They wanted to stop other people from doing this contest. But where I want to push back, or maybe unpack what the court's thinking about, is I don't think the court's words actually get us all the way there. And here's what I'm thinking about. I told you that one of the 2 fundamental ideas of copyright law is this point about independent creation. And to some degree, independent creation seems to solve the problem the court is telling us about. Think of it this way. I read the contest rules. I'm like, wow, great idea. I then run to my PR department and I say, hey folks, I want to tell you about an idea and I'd like you to write it up. My idea is I want to have a contest. They're going to send part of the box. They're going to send their name and their number and their social security number, right? And I articulate the idea to my team, and they write their sentences. Note, I've only brought them the idea. They have now engaged in perfectly permissible independent creation. I gave them the idea, then they write the expression. You might think of it as a clean room, untainted by the original expression. And I hear this judge is saying, Lichtman, if you do that, you did the wonderful, the right thing. If you do it, you know what's going to happen? Your team is going to end up with the same basic expression that we've seen elsewhere. That's the judge's point, that the idea can only be expressed in a couple ways. Fine, he's right. But I would have thought we'd say, great. If I do that, if I take the idea, I run to my team, they write it by themselves, even if they come up with expression that's really similar, it's not infringing. That's the point about independent creation. Remember, when I introduce independent creation, I give you the silly example of if you grew up in an island and had never been exposed to normal, culture, and on the island you came up with a story about a Luke Skywalker and he had a lightsaber and daddy issues. Independent creation means it's okay, even though your work is really similar to Star Wars, as long as you really did it fully independently, no problem. And so on one telling of the story, the judge here is wrong. He's saying they'll copyright all versions, and he's missing the escape valve. I'll take the idea, I'll write it myself, and I'm fine. And what I think the judge really means to tell us is that the Lichtman story would be messy in practice. Right? Think of what would happen. We'd have these ideas where there are only a couple ways to express it. And so what would happen? We know that even people who did it legit, folks who took the idea, had someone else do the expression perfectly clean, we know we'd end up in a world where we'd see a lot of expression and it would look the same. Everybody doing this contest rule would end up with one of a couple versions of these words. And I think what the judge is really worried about is in those cases, a court might think there was copying, even though there wasn't. A judge, a jury might condemn it as copying, even though it wasn't copied. It's my Star Wars example where if I walked over to you and said, hey, look at my story, and you said, that sounds a lot like Star Wars, and I said, yeah, but I did it on a desert island, you would say, I don't believe you. Right? You'd be tempted because of the similarity to say that I copied. And while sure, we'd have lawyers and we'd argue in this or that, point is, this category, ideas that can only be articulated in one or a handful of ways, it's a category where there's going to be a lot of similarity, which means we might get the cases wrong. It's going to look like there was copying, even if there wasn't. And I think what the judge means to say is, I'm afraid that independent creation won't solve the problem, which means that someone who comes up with the idea will write it a couple ways, have copyrights in those ways, and then might actually be able to lock the idea up, because folks who copy would lose, and folks who independently create would look like they copied. And the judge says in those instances, nah, no protection. And again, I'm not really upset about that because there isn't much expression here anyway. In the category cases, when there's a limited number of ways to express the idea, it's going to be such a mess, and there's so little expression anyway. Forget about it. This case is famous for that clarification. And indeed, we refer to that legal rule as the merger doctrine, M-E-R-G-E-R, the merger doctrine. If you have an idea that can only be expressed in one or a handful of ways, we do not protect the expression. Because we're afraid of locking up the idea. We're afraid of checkmate. That's Morrissey. Third of the famous cases that I'm going to show you is this case called Feist. And I'll point out to you, it's a 1991 Supreme Court case, super recent. 1976 is when we wrote the Copyright Act. We had copyright way before then. And it's only in 1991 that we get to this really important case clarifying the idea-expression dichotomy. What's the case about? The copyrighted work at issue is a set of phone books. We had a little town, and the phone company in that little town had made two conventional phone books. A white pages listing names and phone numbers, and a yellow pages organizing, say, plumbers and listing all the plumbers, dentists listing all the dentists, and so on. A yellow pages, and in the yellow pages they ran ads. So if you were a plumber, you could pay the phone company to have your ad on the page that lists all the plumbers in the community. A white pages and yellow pages put out by the original phone company. The one phone company in town did this original work. The case arose because somebody else wanted to take the name number pairs, add them to a much bigger phone directory, and make white and yellow pages. And instead of just being in this little community, it was going to be a much bigger geographic footprint. And the fight was, does copyright stop that? And a couple issues were raised. One is this one. Are name number pairs protected? So the original phone book had like a name, Lichtman, and a phone number, whatever my phone number is, and had a series of name number pairs. And the phone company said, hey, copyright protects those, that's ours, you can't copy those. And indeed, they knew that the other guy had copied, funnily enough, because in their original phone book, they had made fake listings. They'd put Casper the Friendly Ghost and put Casper's phone number and so on. So they had some fake listings they knew the other guy had copied, and they said, you can't copy my name number pairs. Supreme Court looks at this and says, no, we're not going to recognize copyright in name number pairs. And here's what they say. Again, we'll read it and we'll talk about it. Supreme Court says that to qualify for copyright protection, a work must be original to the author. And I'll remind you, 102A used that word too. 102A is the one that says copyright subsists in original works of authorship. So Supreme Court says, look, it's got to be original. Original, as the term is used in copyright, means only that the work was, one, independently created by the author. You didn't copy it. And two, that it possesses at least some minimal degree of creativity. And the court goes on to say it could be tiny, like romance novels, totally fine. But the court says originality is what we're looking for. You didn't copy it, and it is some creativity. And then interestingly, the court, that last line there, court goes on to say that this originality comes from the Constitution. The word's used in 102A, but the Supreme Court hangs its hat on the constitutional language about writings and says those had to be creative. So the court announces, if you want to get into my system, you can't copy it, it's got to have creativity. And they apply that to the name number pairs. Of course, that just pushes the issue one layer further. So as the case actually was framed, the name number pairs were not creative. The phone company had randomly assigned the numbers to the people. But if the court had just said this, we want creativity, I take it my next phone company would be creative. They'd get a rapper, they'd get Beverly Cleary, the children's author, they'd get Tom Clancy, they'd get a bunch of creative people together, and when you came and asked for a phone number, they'd do something creative. You look like someone who should have a couple sevens in your number, whatever it is. And so the court went on to say, be careful, we're looking for creativity, but even more, we're reminding everyone that copyright law doesn't protect facts. And indeed, we know that. That's 102B. 102B says, in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, so on. Facts are excluded too. And so the court said, not only are we not protecting name-number pairs because they're not creative, that takes us part of the way there. Not only that, though, we're also not protecting them because we don't protect facts. And ex ante, ahead of time, maybe these weren't facts. I moved to town, there was no phone number for me. All of a sudden the phone number became into existence thanks to the phone company. Ex ante, ahead of time, it wasn't a fact. But the court's point, I think, is ex post, afterward. Once I assign a number to you, it is a fact. Dial that number, reach me. Dial that number, reach me. It's a fact. And so the court says we want creativity, and we do not protect facts. That's round one of the case. Round two, the court went on to say, all right, fine, if you don't own the name-number pairs, is it possible you own your organization? Remember, these books were organized. The white pages organized alphabetically, the yellow page organized by topic, theme, dentist, plumber, so on. And so the court said, is it possible, even if you don't have rights to the name-number pairs, that you do have rights to your organization? And the court said, maybe. Maybe. And a couple of things. One, let's look at the law first. This is section 101, definition section. Inside section 101, Congress had defined a compilation. A compilation is a work formed by the collection and assembling of pre-existing materials and data, here name-number pairs, that are selected, coordinated, or arranged in such a way that the resulting work as a whole constitutes an original work of authorship. And the court leans into this. Supreme Court does and says, we do allow copyright in your selection, coordination, and arrangement of information. It's possible as long as what you do adds up to something that's original. Again, creativity. And there's more law, just so you know it's there. Inside 103, Congress had said that the subject matter of copyright includes compilations, and in the rest of A and also in B had given some detail, basically saying you get the right in the compilation, but not in the stuff. And so the Supreme Court kind of built on this and said, if you show me a phone book, you don't get the rights in the name-number pairs. But if you have an interesting organization, a creative organization, you'd own the organization. Someone couldn't copy your organization. They could copy the name-number pairs, but not your flow. And then the court said here, yeah, there's nothing. Alphabetizing isn't creative. Grouping by plumber and dentist isn't creative. Maybe, I don't know, had they organized the phone book by height? Great for dating, right? Organize the phone book by height? Maybe. But here the court said to the lower courts, we will tolerate copyright when you select, coordinate, or arrange, but it's got to be creative. And there are a bunch of good examples. If I had done a book of Doug's favorite hymns, where I'm looking at hymns from hundreds of years ago, there's no rights left in the hymns. I couldn't get rights in the hymns, but if I did a book of Doug's 20 favorite hymns, my selection of those 20 would probably be sufficiently creative that I would own rights in my selection. You could still use the hymns, you could make your own selection, just don't copy mine. In this case then, the court says name-number pairs are not protected. It's the creativity point. They're not protected even if you make them up in a clever way because they're facts. And arrangements, yeah, maybe in theory. Arrangements, sure, but they've got to be creative. I'm trying to figure out what to do with phone books. Implications, black letter law, the things I just said to you, that's a big part of the takeaway of Feist. Don't forget, when I ask you, is a work going to be covered, don't forget to ask, is it original to you and is it creative? But as we think about the implications, For phone companies, this was kind of a disaster. And I want to pause on that just for a moment so we think about how cases fit into the bigger dynamics of these markets. Think about phone companies of the day. Phone companies back at that time were heavily regulated. You would have one phone company in the community, they would be regulated as to the service they offer and the price. And indeed, at this time, they were offering yellow and white pages, they were selling ads, and they were making a bunch of money from that. And that was great for you and me. Because as the phone company made money from ads in the phone books, that meant the regulator could pressure phone prices down. They'd make money from the yellow pages, local phone service could be cheaper. This case destroyed that. This case said phone books are not protected by copyright. That meant we had people now making competing phone books, competing for those ad dollars. And the upshot was then phone prices had to go up. And again, this was regulated. So it's not like we were messing with this through a competitive market. No. You'd have one phone company, they offer regulated service. And the Supreme Court, in a copyright case, undermined what we had been doing from a telecommunications regulation standpoint. We had been allowing phone companies to make money on phone books quite intentionally as a way of helping them make some money so we could lower the price of phone service. And this case kind of messed that up. Maybe Congress could have come in and fixed that by passing a new law about who's allowed to make a phone book and so on. But one thing I want to point out to you is there is something interesting going on about phone companies in particular that this case kind of completely misses. The court merely does the copyright issues and never even nods to the bigger picture. But okay. More importantly though, and the reason I really care about this case, is the phone company in this case had argued that the reason they should get copyright, the reason they should have copyright in the name number pairs, was they put in a lot of hard work to generate that information. And they called this theory sweat of the brow. And there had been a bunch of cases between 1976 and 1991 where a lot of courts had said, yeah, that's a good argument. Sure, you might get copyright by being creative, but we might also give out copyright based on sweat of the brow, a recognition that you put in a lot of work to create this thing, and it's vulnerable to copying. Indeed, in some ways, this is the story of copyright. I worry that an author will have to put in a lot of work to make a book or a movie or whatever it is, and that if I don't protect the author, other folks will just take it if it's good, which leaves the author in a really bad spot. And the phone company in this case had made that argument, policy argument, and they said what you should be watching for isn't creativity, it's sweat of the brow, hard work. We should be protecting that work from copying. And Feist, this case, this Supreme Court case, said as a matter of the Constitution, no. You must have creativity. Factual stuff may not be protected. And you probably couldn't care less about phone books. You probably aren't thinking along with me and go, oh no, that's awful, Lichtman. But here's why it kind of is. Think about medical databases. Medical databases are factual information, and I submit to you that in the next decade or two, medical databases are going to be key to medical breakthroughs. We're going to build these databases, hopefully, with like genetic information about our health over time, about environmental factors, all sorts of things. And ideally we'll do it by honoring privacy and consent. Yeah, sure. But we'll build these amazing databases of information, and the information together might then help us figure out some of the subtle stuff that we don't understand right now. Autism, Alzheimer's, whatever it is. This case says that those databases, which are going to be really expensive and hard to build, take enormous resources, but once built would be really vulnerable to copying. This case says those databases can't be copyrighted and indeed can't be protected by the federal government. It's not like we could come in and say, I'm going to protect the database and it's factual, so I won't call it copyright, I'll call it something else. You can't play that kind of game in the Constitution. This case said that the Constitution forbids us from doing copyright-like protections for factual information. And again, the phone book case, whatever, hard to get that upset about it. But I think it means that we can't make laws like this that protect medical databases. Which doesn't mean we won't get them, we will. But it does mean we're going to get fewer of them. We're going to have less money go into the creation of those databases. It means that folks who create them will now try to be very careful because they'll know the government isn't going to protect them from copying. And so if you knock on the door and say, I'd like to use your database, I've got a really promising research project here at UCLA, I'd like to use the database, they might say no, because they'll worry that it will leak out and they can't really do much to stop that legally, other than kind of hoarding, passwords, limiting access, and the like. And this case about phone books, I fear, closed the door on something I really care about. I really want to be able to encourage the creation of medical databases. They're factual, they're not creative, that's great. I don't want creative medical databases. I want factual medical databases. They're really expensive to build just to get all that privacy stuff cleared, just to gather the information. They're really expensive to build. They're incredibly valuable. And this case says they won't be protected, which I think taps the brakes on some of the incentives to get them made. Sweat of the brow could have been this amazing theory of copyright. We would have had to refine it. For instance, if you write a book about Harry S. Truman and gather all the information about his life and publish the book, I don't want you to own the facts. Even if you're the one who figured out some facts about his life, I get it. I don't want sweat of the brow to mean that you control that information. But medical databases, I think we could distinguish. I think there's some sort of spectrum here of some areas where, look, even if you put in a lot of sweat, I don't want to give you a copyright that covers the facts. But I think I would have been tempted to give you copyright at some point, at some level, for some degree of sweat of the brow, in order to give incentives to create factual works. In this case, close that down. Without mentioning it, without talking about it, they decided a really important issue, looking at phone books. And the thing that really bothers me, they said it was constitutional, which makes it really hard to fix. If it had just been 102A, we could maybe someday get Congress to write a better rule. Once you do it constitutional, it's really hard to undo that decision. So the rest of us actually think it's a really important case because it rejects sweat of the brow. All right, last little bit, let me just throw in one modern example and maybe just to cheer us up a little bit. What I want to show you is the courts a little bit are resisting Feist. Just a little, but at least it's something. And the case I want to tell you about is a case about, I'm using the example of the Kelley Blue Book. It wasn't really the Kelley Blue Book. It was a case about one of these books that collects used car values. And indeed, collects isn't really fair. It tries to predict them. You probably use these, the Blue Book, the Red Book, there are a bunch of them, it turns out. But there are these books where kind of smart economists try to tell us what various used cars are worth. And you can literally look your car up. I've got a Honda Civic, it's got 20,000 miles, it's 7 years old, it's in good condition, and it's sitting in Cleveland. And you look it up based on that information, and it tells you the price, and maybe gives you even more. If you're buying it, you should go for this price. If you're selling it, that price. And we use this, you probably have used this, used cars, you're turning it into the dealer when you get a new car, and they give you some discount based on the value of the used one. Or, I hope it doesn't ever happen to you, but you're in a car accident and your car is totaled, and so you have to get the cash out value of the car. These books of used cars values help us do all these transactions. The case was about, what does a copyright in a book like this mean? Because in the actual case, one of the big companies had made a book like this, and somebody else had copied the name number pairs. Where here it's not a phone book name number, it's the name of your car, city, mileage, and so on. That information is the name, and the number is its value. And the rival had copied that information and was competing. And interestingly, I think an easy application of Feist would have been to say, sorry, it's a factual database, and you can't get protection for it. And yet the court fought back and said, no, this one's different, and recognized copyright. And I'll grant you, it is a little different, but not hugely so. The court emphasized that these numbers weren't facts out in the wild. They were things that were developed using judgment and various categories of information. Although that sounds a lot like sweat of the brow to me. But the court said, hey, this isn't purely factual. It is the result of judgment, sweat, effort, and the like. And the court said, and the end result isn't factual because it's a prediction, it's an estimate. And again, I don't love these distinctions. I think maybe, but for example, imagine how Kelley Blue Book advertises. They don't say our numbers are creative. They say our numbers are the best prediction of the fact as to what the dollar figure would be if you sold your car. They're telling you that they're trying to capture factual information. What is the market clearing price for that car in that city right now? That's what they're trying to do. And so the court kind of tried to draw distinctions, but they're really tough. I think the reality of the description is there's sweat of the brow here, there's real effort, but they're trying to generate facts. And I'll even go further. Once Blue Book lists a number, it kind of becomes a fact, which is to say, if you total your vehicle, a lot of state and local rules, what do they say? They say the insurance company has to give you the Kelley Blue Book value. It becomes the value that you get. And so what I like about the case is, gosh, it looks really close to Feist. Could I distinguish it? Yeah, a little bit here or there, but it looks really close. And yet the court said, no, it's different. We're going to allow copyright in this group of name number pairs. We're going to protect this group of facts. And they distinguished it along these little arguments, but they kind of pushed back and made room for this protection. And they even wrote in the opinion, but man, if we don't do this, we're going to destroy the incentive to create these works. And so they characterized it as not quite being the same as a fact. They drew a distinction to name number pairs like phone book. But I kind of read the case as the courts will push back a little bit and make at least a little room to protect this category of stuff that I really care about. Is it enough? No. I think it'd be hard pressed to protect a big medical database, even if you get a court like the one that decided the Blue Book case. I think Feist makes it really hard to do this meaningfully. But I at least want to show you there's a little bit of slippage where the courts are trying to find ways to distinguish Feist when they realize that if we don't protect factual information, if we don't at least peek at hard work, maybe we're going to destroy stuff we really value. So a little bit of a silver lining, but the big picture of black letter law really is hostile to this category of work. All right, what have we covered in this video? Baker versus Selden tells you go to the patent system if you want to own the idea. Morrissey, famous for the merger doctrine. M-E-R-G-E-R. This point that if you have an idea that can only be expressed a limited number of ways, we won't protect any of them because we're afraid the system might accidentally lock up ideas. Merger, that's Morrissey. Feist, big picture teaching of Feist is to get into our copyright system. So sorry, Lichtman, you got to show me you didn't copy, and it has a modicum of creativity. If it doesn't have creativity, it ain't welcome. Feist, the big teaching there. Then the secondary points about compilations, they come in if they're sufficiently creative, and this rejection of sweat of the brow. We're going to really have a hard time championing cases if all you can tell me is, I put in a lot of work and I'm at risk. Lastly, I touched the very quick modern example to say there's a little room to argue a good lawyer might be able to carve out enough distinctions to survive Feist. All right, that's what I want to cover in this video on idea expression.